Court does call the case of People State and versus Jerome Burns.
Good morning, Your Honor. Marie House Assistant Prosecuting Attorney. Back to people.
And good morning again, Your Honor. Assistant Public Defender Chinazi Carey on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
Jerome Burns. All right. Are we ready to?
Your Honor, a few things. I've been communicating with defense counsel. We have witnesses here. Victim is on her way. Sergeant Matthews is driving her. Currently, I believe they hit some traffic, but we have our other witnesses present and ready. I did want to make a record. We received a great deal of evidence from defendant's phone. As the board likely remembers, we had a preliminary, an extraction. I shared that with defense counsel because it was of potentially exculpatory nature. I was also though very clear that's a preliminary finding. There was ongoing extractions from the phone and analysis that needed to be done. I was initially sent 2 zip files of what was extracted from the phone. Background to this is that there was at least one hidden folder in the defendant's iPhone that had biometrics associated with it. So essentially they could get into the phone, but they weren't able to get into the hidden folder. So we were looking at options for that. The extraction we received didn't work on any of the county computers, so I was unable to, yes. Ironically, I was unable to pull that up. I had informed defense counsel of having that, but also that I wasn't able to open it. So the next step was asking them, hey, is there another way we could do this where I could actually view this evidence and share it with counsel? I believe it was yesterday. And I will say Sergeant Matthews went above and beyond in trying to do things quickly. He was able to get 2 thumb drives, one for prosecution, one for defense, copied over to our office. I notified defense counsel. I believe they have picked it up since and are in possession of their copy. But it's a lot of information, Your Honor. And a lot of the information relates not only to the preliminary report that I shared with counsel. In essence, it gives a lot more context than what I have been able to view, give context to that first piece of evidence. It's also evidence that we would want to ask the victim about. So the potentially exculpatory information, I believe, would necessitate the victim testifying again, unfortunately, given that evidence, but also the evidence that we are just recently in possession of would speak to that very closely. And I can go into further details to court.
Oh, I just want to make sure I'm understanding. So there's evidence that may be exculpatory, which would require the victim to reappear and testify.
Correct, Your Honor, to give context to that piece of evidence, but we also now the evidence that we have received as of yesterday, it gives a greater context to that preliminary piece that we shared with defense.
Got it.
The reason for sharing that first is because of the potentially exculpatory nature. I wanted to make sure they had it and they were ready. But of course, there's a lot more to it. And what we have other witnesses, I'm ready to continue with those witnesses so that they don't have to keep reappearing. But I'm not sure I'm comfortable proceeding with the victim's testimony until both sides have had a chance to review this additional evidence off defendant's phone.
Okay.
As I stated, victim is on her way here. She does have a son. I don't know if she was able to get childcare for him or he'll be with her. So I don't believe we reached a consensus this morning, but I did speak to counsel about, for her testimony, do we need to keep her here and take that testimony today? As I stated, and I'll state again for the record, I'm not comfortable until both sides have looked at the evidence. I'm not comfortable directing her on it, and I'll leave up to counsel how she feels about cross-examining without those pieces. But as for the other witnesses, Your Honor, we would be ready.
Your Honor, we find ourselves in a pretty difficult situation because we have not been able to review all of the information from the thumb drive. I asked sister counsel, she's unaware because she hasn't gone through it either, if any of the information in the thumb drive may pertain to the witnesses that are present now and ready to have testimony taken from them. I don't see why there would be. However, there was some information just in the preliminary, pieces that were sent over last week or a few weeks back, that may have occurred around the time of the interaction with one or maybe all three of the witnesses present today, specifically some communication between my client and the complaining witness. We're not sure who was around at that time, but I just don't know what else is in the phone. There's a great deal. I am not experienced in sieving through this type of data. I'm literally just clicking on every folder or file and
I thought you worked for the NSA. No, I'm sorry, go ahead.
Not on the right.
In my prior life.
Yeah, okay.
So, and that's why I find it difficult to say, yes, I'm ready to proceed on the three witnesses that we have. Yes, I'm okay with an adjournment of, the information from the complaining witness. And I know my client's position 100%. He has been in custody throughout this entire period. He is very eager to resolve this matter. We received some very disturbing news from his family yesterday. His father's currently in the hospital, and he's been really struggling to assist with his mom. But I know that my conversations with him have always pulled out his desire to move forward and continue this case along. So we're really at a crossroads right now, Judge.
Right, and just so that we're clear, part of the reason the court agreed to adjourn the matter was because my understanding was the defendant believed that there was something that was exculpatory on the phone. And so that's why we even started down this path. Just that there, I'm not blaming anybody, it just is what it is. With reference to, I'm sorry, Ms. Eckenroley, were you done?
Sorry.
Okay, no, I just wanted to make sure. With reference there, you said you had three witnesses today.
We have three witnesses, Your Honor. Two of them are in the gallery. One is the officer who responded. The other one is a social worker who spoke to the victim at the time at the hospital after the assault. So they would be ready. We also do have Sergeant Matthews. Sergeant Matthews would be able to start today. We may want to recall him after the victim's testimony, depending, but he'd be the third witness that could start testifying today.
Got it.
And I share defense counsel's lack of knowledge of technical things. So when she asked me about the messages, I was able to get through some of them. Of course, not all of it. It is a great deal of evidence. And I would agree that there are text messages, and those we do have timestamps, and Sergeant Matthews could speak to from defendant's phone, defendant messaging victim around the time that it seemed it was becoming clear to him that there might be some police involvement and things like that. I'm not sure if that affects Officer Morton's testimony. I mean, he responded, he did what he did, but I'll leave that up to the court.
Well, I guess I initially, let's take out, there's a social worker to testify who, and this may be the more difficult one for the court to try to analyze, and maybe part of the defendant's point, that
It wasn't me.
Oh, you don't care? You don't care? No, man, I feel, that thing goes off, nothing. Then that goes off, nothing. No. You got me? Okay, thank you, Ann. No, don't worry about it, man. I feel safe. So with reference to the social worker who spoke to the victim afterwards, I would have to say I might be a little bit concerned if there are concerns with what the victim has testified to. and the victim is relaying certain information to the social worker. I'm not sure, maybe the parties can clarify it if they can, or I don't know. It would seem to me that getting through or understanding what's on the phone is also going to be cloaked in that same context as the victim. If that made any sense.
It did make sense, Your Honor, and I'm racking my brain as to with the preliminary information we have, my concern, defense counsel might disagree, my concern isn't necessarily what the victim said. Our understanding of the evidence, especially with the little of the new evidence I've reviewed, is that the potentially exculpatory evidence, our perspective is that it's not exculpatory because there's a greater context and we have theories and so on. And I think the evidence will highlight that. However, again, like I said, defense counsel might disagree.
Well, and I guess my point to that might be, she might disagree or may not know.
Correct.
Which may be worse.
Yes, Your Honor.
Because it's that greater context, I guess, piece of of that evidence that might not only have some greater context to what the victim says, but might also have greater context to what the victim said to the social worker and what the social worker says.
I understand.
Is that sort of what you're referring to, Ms. Ackenwood?
That's correct, Your Honor. But yes, not knowing what's on the phone, I don't know how it pertains to our social worker or even the officers, because again, there's from the preliminary information, there were some communications that fell within that timestamp of after the event, during the time that other parties began to get involved. I don't know. And we just know that from the preliminary.
And you know, the difference between the preliminary, other than the obvious difference, the preliminary information we're able to get evidence about the time stamps, because in part of that report and part of the supplement, I believe, Sergeant Matthews outlines this time, this day, this text was sent, and so on. With the new evidence, I don't have a way of knowing the timestamps on it, and the defense does either. So we would need someone to testify to all of that. And I don't know if Sergeant Matthews has had a chance to review all of it, because he similarly had a problem opening the initial files and has only since yesterday had access to all the information off the phone.
And Judge, I just wanna, I guess I need to just put this on the record. I know that I think it's important that the court notes that my client never requested for the people to get his phone. My client never requested.
Right. I mean, I agree with that piece, but and I'll certainly let you finish. What my point was, the defendant, at least as I was informed, the defendant wanted his phone, which he believed to be in his property.
Correct.
That his reason for that is because there was a belief that there may be something that might be exculpatory on the phone.
Correct.
Okay. When the defendant was, or at least the court was aware that he wanted the phone, I was then informed that the police agency had picked up his phone and had his phone. So if anything, I'm saying in terms of the request that it was the defendant who was requesting the police go through his phone, I don't think that's not what I meant to say. What I meant to say is it transpired that way because there was something there. The people, to their credit, then said, if there is something that is exculpatory, then we want to make sure that the defendant has that. So that might be a clear picture, but I'll let you go ahead.
Sure. Yeah, so that is correct, Your Honor, but I think the piece that the court should probably also know is that the only reason that they picked up the phone was because my client was asking a family member to come and get his phone for him so that he could instruct us on how to get that evidence out of his phone. And the police department overheard that call and then took it upon themselves to come and pick the phone up. And then that's where we got into this entire delay because there was negotiations as to how we were going to get it to the phone and things of that nature. So it does not change where we are. I just felt that it was important to clarify the record to that point.
And please understand that I wasn't trying to, and I think I may have said it at the end of my first statement. I'm not trying to blame anybody for the delay. I'm not trying to say the defendant is trying to delay this out or the people. It is what it is. I just wanted it that we, and I'll take you at your word for how or why they picked up the phone. But suffice it to say that somehow or another, that train started rolling up tracks.
Correct.
And so
Absolutely.
we all had to deal with it. So.
Even if I could just add one thing, and it's simple for the record, because I know everybody here is aware of this. When we were here and there was information from the defendant that he wanted potential exculpatory things off his phone, I want to be clear, it wasn't a PCC. We were here for exam. The victim was here. People were ready to go. What I want to add to that is that defendant also has a bond violation, and I know he hasn't been sentenced on that bond violation, and I'm not sure what the sentence would be. But this is there are many factors that go into this, and that is one of them. And the violation is such that it's not just a minor technical violation, it's quite a serious one.
So I guess the defendant wants to proceed right away, and I get everything that counsel has stated, but I'm worried, just secondarily, that you'd be placed in a position of attempting to try to cross-examine a witness for your client's benefit, where you don't have benefit of everything. And that really is fundamentally my big concern.
Your Honor, I'd say the people share that concern, and in communications with counsel, I also want to be clear that if we don't continue today, that is not from the people not being ready. That is not from the people saying we don't want to continue. In fact, as I stated, the victim is on her way despite many difficulties to try to make it here, and our witnesses are present. So for as much as it helps to the defendant's benefit, this is us also trying to be very careful in how we go about things. None of us want there to be issues on appeal. We all want to make sure that we're very careful and respecting not only the rights of the victim and the people, but really the rights of the defendant.
Right. Ms. Eckenrode, have you had a detailed conversation with your client about going forward today? I mean, I realize that some of the issues that the court is raising, you may not have because I've raised those, but you're smarter than I am, so you may already thought about that.
And Judge, I mean, if the court is okay with giving me a moment to, now that he's been able to sit here and listen to all sides of it, yeah.
And I'm not going to have a problem with that. Let me. What I've said about the social worker, does either party see with reference to the two officers that same potential issue arising?
Your Honor, it comes down to what Your Honor very eloquently put. We don't necessarily know. I don't have reason to believe. There's nothing I've seen up until now that would suggest that. There's of the things I've seen, there's nothing that would make me think that we couldn't proceed with the officer's testimony. But
I'm sorry, I don't mean to interrupt, but the officer spoke with the victim.
Correct, yes.
correct?
Yes.
And from speaking with the victim, a report, that's part of the report, right?
Yes, Your Honor. So there was an interview with the victim. There was an interview, of course, with the social worker who had spoken to the victim. And there was at least one interview with the defendant.
Okay. I mean, and I haven't had a chance to necessarily think that entirely through, but it would seem to me, oh my goodness.
Instant smile, Your Honor. Just making sure we're doing our
I can
jobs.
hang
just
out for
right.
a little while for the court's next recess.
Well, I'm out. All right. It is so good to see you.
Thank you. Good to be seen.
I'm happy now. Despite your non-attention to my safety. I'm happy. What? So let me just put it in a nutshell. It would seem to me, and maybe this would be the conversation that needs to be had, that anyone who spoke with the victim is going to fall, in my mind, into that same potential concern regarding placing context around what her statements are. I think we're in the same boat. I picked the social worker initially because it was going to be difficult, but there was also going to be a closer conversation between the victim and the social worker. But I think if the officer interviewed the victim, that same thing is going to happen or potentially happen. In the Simpsons.
Your Honor, may we approach just briefly?
No, this is where it starts. You know, I'm going to just tell you, I walked in here, two of my favorite attorneys, and I said, this is going to be a good day to come back from vacation. You have both ruined that. You may have ruined.
14A District Court, County, Washington, State of Michigan is now back in session. The Honorable Judge.
You may be seated. We're going to need that seat. Thank you, Ms. Perry. Yeah, you can tell Garen and Simon are really gentlemen because when thought I'd just throw that out there. I'm just observing. Well, I didn't expect Simon, but Garen. Court does call the case of the people. We call the case of the people versus Burns.
Good afternoon, Your Honor. Grace Andos, the prosecuting attorney about people.
And good afternoon, Your Honor. Assistant Public Defender Shanaji Karyaki-Murley on behalf of Mr. Jerome Burns. Mr. Burns, would you state your name for the record?
Jerome Burns.
All right, very good.
So, Your Honor, thank you for the court's patience and allowing us to talk through a few things. As I indicated to Your Honor and defense counsel, I've looked through a great deal of the evidence. I was handed a essentially summarized report by the detective who did the extraction from the phone. I shared that for today's purposes with defense counsel. We both kind of skimmed through it. With what was in that report, I felt comfortable proceeding today with the responding officer, with the social worker witness, and starting with Sergeant Matthews. I was not necessarily comfortable proceeding with the testimony from the victim until I've looked at everything more at length. So I guess we wouldn't have a request to adjourn. However, we also understand defense counsel's side of things and want to be understanding of the concerns that she has and time that she may need to look through everything. So we also wouldn't object to an adjournment at this stage.
And Your Honor, I think that she did state the fact that there was a new summary that was provided to us today by the officer who was able to do the extraction from the phone. I did have an opportunity just to glance at that summary. I spoke with my client. Previously, the court is always obviously aware that his position was for us to continue on with the exam today. In light of the new information, by way of summary that was submitted to us today, I need time to go over it with my client and see if there's any insight or context that he would be able to add to it for me. Most of this is communications with the complaining witness specifically. So there's just a lot of information that we have still yet to go over. So I guess that although my client, for the record, is not asking for the adjournment, we're just letting the court know what position we're in right now with the information that's been presented to us.
All right. Understood. And so from the court's perspective, and I'm going to adjourn the matter, finding good cause to do so. Counsel's been very good at explaining to me exactly where the parties are. I think it would certainly behoove the defendant to be able to have his attorney go through that information and then go through that with him in fairness. As I also expressed to counsel while we were in chambers, I strive to make sure that the decisions that I render in these cases, in every case, is the correct decision. And it would worry the court a bit that if there's information out there that is not being provided to the court that may give either some context or understanding as to the testimony that I'm hearing. So for those reasons, the court will adjourn the matter. I will be adjourning it, also part of the discussion in back, realizing the defendant is in custody, has been in custody. And that there are, without going into the details of it, vacations that are scheduled and other things, plans that people have made, and so that we can have consistency. We picked August 13th as a date to continue. Court's going to do, and that we'll do that August 13th at 9 a.m. The court, for its part, is flipping its docket to handle what would be in the morning, in the afternoon, to try to accommodate this and to make sure that we can get this done in at least a reasonable period in time. Counsel has also let me know they think that will be enough time for them to be able to get through everything. So that there's a full understanding, and from the defense side, being able to also discuss that with the defendant. Right. So August 13th, 2025, 9 a.m. for me for the continuation.
And Judge, if I may address Barnes? Your Honor, with obviously the court is very aware of the continuances that we've had in this matter. Mr. Burns has been in custody for 81 days to date from the date of the original arrest. I know that there is a current issue, or at least a bond violation that he has already entered a plea to, that the court has yet to sentence him for. I do not know what the court is going to do. I'm not sure if the court has been able to make a decision, especially based on the status of the case as is. I received information from my client's mother on yesterday that his father is currently in the hospital. He suffered a stroke on Friday, and he has been hospitalized since then. Because my client does not have telephone access or anything of that nature, he had been completely unaware of that until I had spoken with his mother. And then I was able to relay that information to him. She has been finding it very difficult to handle her husband's affairs and to assist with his medical upkeep, especially when he is going to be released by God's grace He will be able to be released sometime soon, and he'll have a significant treatment regimen that he will have to undergo. I know the court is aware that my client lives with his parents and had been living with his parents prior to this situation. They're not considered as elderly, but they are older. And his mother will need some assistance. I know that the court has heard some testimony in this matter. We'd like to ask that the court consider giving him a bond that he would be able to post, ideally, preferably a personal recognizance bond. I know that there are things that the court can put in place to protect or address any concerns that they may have for the complaining witness. He is not a flight risk. The court knows that his parents have been at every one of his court hearings from the beginning. So we know that he himself will be at every one of the court hearings based on what he has assured us. The way that this case has gone in so many different directions, Mr. Burns 1000% understands that he is fully in control of what happens next. If the court is willing to give him a personal recognizance bond, I dare to say that he understands that any actions on his behalf would negatively impact his case, because they have. Everything that has happened thus far that has brought us to the number of continuances that we've had. I've spoken with them. Most of them, if not all of them, have to deal with some type of action that was taken by him. If that has not taught him that his actions directly impact the outcome of the case, or at least the ability for us to try this case in a fair manner, I don't know what else would help him do that. I believe that he is understanding the importance of maintaining his bond. I believe he understands the importance of no contact with the complaining witness in any shape or fashion, with the issues with his father, the assistance that's needed by his parents. We're asking that the court make a consideration of giving him a bond, and in the alternative, judge, at least allowing him to be able to communicate with his parents so that he'd be able to keep up with what is happening with his dad. We prefer that he be given a PR bond. I mean, he has been trying his absolute best to aid in his defense from the jail. It has been quite difficult because he only has his parents to rely on to relay and give us whatever information they may have. So that is our request today. Primarily based on the number of continuances that we've had. I know we've talked about it on the record, and not that anyone is at fault for that, but he's been in jail for 81 days on this case, Judge. So we're asking for a personal recognizance bond.
Your Honor, we have a great deal of concern in this case. We had a concern initially when this case was charged. That concern has done nothing but grow as this case has progressed. We heard testimony from the victim, quite extensive testimony about the level of coercive control that this defendant had on her. That gives us no hope that that has changed. Part of the reason that we don't have that hope and don't believe that anything's changed in his mind for the better, at least if anything has changed for the worse, the actions he took while he was incarcerated after being given very specific conditions of bond. At that point, it should have been clear to him, if it weren't previously, that engaging in behavior that makes things more difficult for the victim, who is the mother of his child, is not going to be beneficial to him. What he then decided to do is make several calls, ensuring, first of all, he fought her having access to a vehicle to transport their sick child while we were in court. Even to the point where his father was willing to hand over keys, and we thought we had it resolved, and he refused. Then when the court ordered, keys need to be turned over to the victim, she needs to have transportation. The court had a long conversation with him about the situation and what would be appropriate, what he needed to do. He then decided it'd be a good idea to have people, third parties, contact the bank, trying to get this car repossessed, going so far as to say the victim who was staying at the domestic violence shelter at the time, make sure that they come and repossess the vehicle as she's trying to unload her things. I mean, this is a woman who has had everything taken from her. She has no place to live. She had no transportation, and she's caring for a sick child, defendant's sick child. He also, during those calls, made statements about how he would have assaulted Your Honor, if he wasn't handcuffed. All of that is plenty concerning. And in addition to that, he made statements on the jail calls, and we heard through the victim's testimony that he has made statements, and I believe the evidence we now have is going to corroborate that, of taking their son away, and that the victim would never see their son again. She also testified, of course, that was part of the reason that she gave it in this case to the sexual assault, and it was a big part of her concern in this case. So when we're talking about victim safety, we have concerns because of that course of control, because of the hourly check-ins he required from the victim, knowing exactly where she is, who she's with, and so on. That doesn't just go away. We also do have concerns that he would take their son and disappear. So both for flight risk and for victim safety, we have a lot of concerns. We'd ask the court to deny the motion.
Yes, Your Honor, I just wanted to address a couple of the issues that were raised by the people. At this point, my client does not have a vehicle. The vehicle was turned over to the complaining witness, and obviously the court is aware that the vehicle is either not working or something to that effect, because the complaining witness has needed assistance from the people to get to court on each of these hearings. So he is going to completely have to start all over. We've already pled to the bond violation. I think that it should be noted that no contact with the complaining witness was actually made. There were attempts from my client. We do not deny that, Your Honor. Most of that was due to frustration and what he was dealing with at the time, and just trying to understand how he found himself in this situation. He has taken responsibility for that. And I think that that should give him some type of a benefit of the doubt, Your Honor, because he has been able to take accountability and responsibility for the actions that he did commit. However, the complaining witness left the home that was shared by all of these parties well before this incident happened. He does not have any control over her. If he did, she would have still been in the house. The only reason that we're here right now is because their son was in the hospital, and they were at the hospital together. Whatever control or coercion or dominance the people believe that he has over the complaining witness, there has been no showing that that is the case ever since she left the home. So I don't think that that is a concern that the court should have. My client has much more important things that he needs to worry about right now, rather than whatever it is that's going on with his relationship. He has not tried to contact her directly while he was here. The only contact that was alleged was the fact that he asked someone to go and have the car repossessed because it's up for repossession. And I mean, quite frankly, Your Honor, he is still financially responsible for a vehicle that he no longer had control over. And his position was, if I don't have control over the vehicle, then let the bank take the vehicle back, and everybody will just deal with things the way that they were dealing with it prior to that. I do not think that the court should or would have any concerns with my client contacting her, having any issues. He wants to focus on his family, his father, and his mother. He has work that he needs to do, Your Honor. He needs to be able to help his parents financially. That is the position that we're in right now. He has to start all over. He has no leg to stand on right now other than a place to live, which would be at his parents' home. I think that a hot zone tether, a tether of some sort, would be able to protect him. He doesn't even have a phone, Judge. The phone that he did have is in the possession of the police department. He would be using his parents' phones, if anything. So he doesn't even have much to work with. So I don't think that the concerns that the people have for the victim's safety or the complaining witness's safety in this matter are valid, because my client can barely take care of himself at this point.
The court, having looked at it and also having been familiar with the bond violation that I've yet to sentence the defendant on, certainly given, and again, it's not anyone's fault necessarily, the continue time to make sure that all of the evidence is properly analyzed by each side. The court, in any sentence that it does impose, and I did represent this to counsel, will take into account the time that the defendant, I'm not making any guarantee as to what extent, but we'll take that into account in terms of any sentence that it would impose. I still do consider the defendant to be risk to public safety and to the victim in particular in this case, and would deny the defendant's request for a bond reduction at this time. I will, however, given light of given notice of the circumstances involving his father. His father, I know, had been in these proceedings in the previous times, that I would permit, although I have revoked his phone privileges, to the extent it can be arranged with the Washington County Sheriff's Office in jail, I would permit the defendant to call his father while he is at the hospital one time per week, so that at least he can have communication with his dad. All right. And maybe then facilitate some of the issues that his mother might be running into in terms of the caring of the house. So, counsel, if you prepare an order to that effect. But once, so that I'm clear, once his dad leaves the hospital, his phone privileges will go back to the status of being absolutely revoked. All right.
Your Honor, may I just add one thing? I'd asked the court because part of, and I was gonna respond to counsel, but I felt it unnecessary at the time. Part of the jail calls indicated that he was asking his parents to contact the victim to have her essentially get rid of this case. So maybe a warning that, so he's very clear that these conversations, once a week, cannot be about the case, about the victim or anything like that. Thank you.
Yes, and I think that ought to be clear, and you understand that, Mr. Burns.
Yes.
All right. So the case should not be discussed, certainly no directive should be given to your dad in terms of what to do or anything else along those lines. If I find that to be the case, that's just going to be another violation of my order, and I don't think we want to end up in that situation. All right. I'm doing it solely because having found out this information, your dad's in the hospital. I think that as an act of grace, the court is going to give you the opportunity to at least speak with your dad. All right. Okay. Thank you.
Thank you.
Court does call the case of the people versus Lisa Keebler.
John Shea, Your Honor, with and on behalf of Ms. Keebler for sentencing. May Ms. Pilara and I approach briefly?
Right. Yes. Okay. Date and time set for sentencing. Ms. Flair, go ahead.
Yes, Your Honor, Teresa Flair on behalf of probation. Your Honor, I did want to make the court aware that I do know Ms. Keebler from a prior work relationship, which we did have some social events that we had while that was taking place. I did want to make the court aware of that. However, I don't believe that my recommendation to the court is impacted in any way. I believe that the recommendation that I provided to the court would be like any other probationer that people. And that those events happened a while ago, a long while ago.
Not wanting to age oneself, you're just saying a while.
That's correct.
Okay, all right. And I will just say that I had previously disclosed in taking the case that I also know Ms. Keebler. And we had a working relationship, both the state prosecutor as well as defense counsel. Saw no issue with this court proceeding with the case, given that. I would also say that I would have known and knew in the past that there was a working relationship as between Ms. Pilara and Ms. Keebler. And I would expect nothing less from Ms. Pilara, and she has never disappointed me that she would not let that affect her in any way. And certainly when I look at this recommendation, it is a standard recommendation and does comport with this court's manner of sentencing in these types of cases. So unless there's an objection from the defense in that
I
regard.
didn't object then, and I'm certainly not objecting now. I think the court's correct in its characterization of the recommendation, and I appreciate Ms. Pilara putting for disclosure on the record.
All right, go ahead.
Your Honor, we have reviewed the recommendation. We've also reviewed the assessment that accompanied the recommendation, including in the conference room today, but also prior to this. We, with the exception of, and then we discussed this at the bench, Ms. Keebler needing some accommodations when it comes to alcohol treatment, which we discussed, don't have any other comment really with respect to the recommendation. It is as I would have expected, and I explained that to Ms. Keebler. So we're prepared for the court to proceed forward accordingly.
All right. Keebler, is there anything you'd like to tell the court before I impose that?
Your Honor, how do I adequately apologize for being in front of you today? If anyone knows better, it's me. I want to thank you for overseeing my case today. This has been an incredibly humbling experience, and I promise you will not see me in this capacity again. Thank you.
Thank you, Ms. Keebler. You know, and I'll just say, people certainly can find themselves in difficult circumstances, but I think that much of it, sometimes behind the scenes, the way you have, at least the time that I've known you, served the people of Washington County. Mistakes can be made, right? But it doesn't by any means diminish the service that you give to the people here. This court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of IOP treatment, attendance at weekly AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. This is therefore the sentence of the court that I will place you on 18 months probation. I will order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, and $540 probation oversight fees. When can that be paid?
I can pay it today.
Thank you. It will be paid today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an intensive outpatient substance treatment, including all recommended aftercare with status reports to probation. I will just note in that regard that much like with any defendant, that where an accommodation is required, we will provide that accommodation for the defendant.
Thank you.
You are to attend 2 AA meetings per week with monthly verification to probation. You provide proof of victims impact panel attendance to probation. I will continue to scram Tether for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. Thank you. Good luck to you, Ms. Keebler.
Thank you.
Thank you, Judge.
Thank you. Court does call the case, People versus Edward Harris. Okay, can you hear me, Mr. Harris? Can you hear me?
Yeah,
Okay, good enough.
how you doing, Your Honor?
I'm doing well.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Harris. Mr. Harris, can you state your name for the record, please?
Edward Harris.
Teresa Clare on behalf of probation, Your Honor, Mr. Harris is before the court for a violation of probation hearing. Mr. Harris is in violation of the terms ordered by this court in that he owes a balance of $1,095, having made no payments. He failed to report to probation as directed, failed to provide proof of substance abuse treatment, and failed to complete or provide proof of a mental health assessment. Mr. Harris additionally has had new police contact with a new case being filed or submitted to the prosecutor's office. Your Honor, that alleged date of offense was May 3rd, 2025, with the requested charges of larceny in a building. Probation is also aware that Mr. Harris has in violation of probation hearings out of circuit court. That's going to be addressed there. It's my understanding from the felony probation office that he's likely to serve jail time in those matters. Given all of the circumstances, probation is recommending that Mr. Harris serve 365 days in jail with credit for 88 days that he served today, that he served the balance. If he completes the in-jail MRT program, for the court to consider early release upon completion of that, waiving all other terms except his financial obligations and discharging him from probation.
Your Honor, I did have a chance to speak with Mr. Harrison, Ms. Pilara about this. I'm going to ask for an adjournment of this hearing, actually, to see what happens both on the felony case, as well as I would like to get some documentation from Mr. Harris's caretaker, his sister. He's been having pretty significant memory issues. He had an aneurysm earlier this year, and I want to make sure that if that could have an impact on the sentence, the court and probation has that information, and to see if felony probation has that information as well. I mean, frankly, Your Honor, if I ask Mr. Harris if he's been diagnosed with dementia or Alzheimer's, he doesn't remember. So he's been having some memory issues, and like I said, his sister is his full-time caretaker. So I just would like a chance to speak with her more, to know more about what's going on with him.
Well, it would seem to me that both could happen. I mean, the significant penalty in this case is the jail time that I would be imposing. I am certainly, if information is provided after you speak with this, is to probation and into the court to reconsider the amount of time, if any, that the defendant would serve. So I'm going to decline the adjournment. I think I'm going to go ahead with the sentencing with that caveat that if you provide that information, I'll take a look at.
Sure. If anything comes to light, I'll get it to the court.
All right. Okay. Sir, anything you want to tell me before I impose sentence?
No.
All right. Given all of that, I'm going to order 365 days in jail, credit 88 days that he served defendant, and I'll order the defendant to serve the balance. I will indicate also that the defendant is to complete the in-jail MRT program. I will consider an early release upon completion of that program, as well as if other factors are submitted to the court that would dictate an early release. I will waive all other further terms except his financial obligations, discharge him from probation without improvement.
Your Honor, if I may ask one question.
Yeah.
I don't know if when Mr. Harris walks out of this room, he's going to remember to enroll in the MRT. Will the jail, since it's court ordered, will the jail automatically enroll him? Do you know? Or any
I don't
of our
think it's automatic.
officers?
But,
I can get in touch with the jail and see if
why don't we?
they can help me
So
facilitate that.
Okay.
Okay.
We'll do it that way.
Okay, thank
All
you.
right.
Thank you.
Thank you. You take care of yourself, sir.
Okay.
That's called the case of the people versus Daniel Naugle.
Good afternoon, Your Honor. Brendan Balsam, appearing on behalf of Daniel Naugle.
I'm here as well, sir.
State your name for the record, sir.
Daniel Allen Naugle.
You have it. That's all what.
Hello?
All right. Yes. Go
Your
ahead.
Honor,
Make-
Your Honor,
making-
today's, go ahead, I'm sorry.
No, I'm making sure you had me.
Oh, we've got you. Okay,
Oh,
go
boy.
ahead.
Your Honor, today's date and time set for sentencing in this matter. That being said, I had the opportunity to review the pre-sentence report with Mr. Naugle. The only correction I'd ask the court to make, it just is a simple one. It's on the first page where it says place of birth. It says Tecumseh, NI. That should reflect MI for Michigan. But other than that, everything is factually accurate. No corrections, additions, or deletions.
Anything either of you'd like to say before I do impose sentence?
Just a few things on his behalf, Your Honor. Mr. Naugle is 45 years old. He does reside in Tecumseh. He's never been in trouble before. He does have 2 children. He's been in a long-term relationship. He just started a new job that he's very proud of. He did accept responsibility for his actions. He was very candid with the probation officer about the incident. He's fortunate that nobody was injured or even worse, killed. With that being said, Your Honor, I think the recommendations are fair. I would ask you to adopt those. There is one caveat. He did indicate to me just recently that he has a pre-planned trip from August 13th through 19th. It's a family vacation to Tennessee, and he's asking for permission to be able to travel.
Sir, anything you want to tell me before I impose sentence?
I would like to just apologize to the court and the people for my actions. Was a bad judgment call on my end, and I appreciate everybody's time and effort and helping me with this and getting this on the right path.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol education, attendance at 1 AA meeting per week for the next 90 days, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court will place you on 9 months probation, order $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $270 probation oversight fees. When can you pay that, sir?
I would ask if it would be possible for me to pay that back in 4 equal payments with the option to pay early if I can do so.
We'll always take your money early. But
Perfect.
when do you want to start this and how much are you going to pay up front?
I can pay $350 up front today.
All right. Pay $350 today, and then it'll be a payment plan as arranged by probation for 3 other equal installments or other installments.
Okay, sir.
There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You're to attend 1 A meeting per week for the next 90 days with verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I'll order 93 days in jail, credit for 1. The balance is suspended. I will also order the defendant may travel to Tennessee, and that was the 13th through the 19th. Is that correct, counsel?
Yes, Your Honor.
13th through the 19th of August. Not sure why you want to go to Tennessee, but what the heck. All
I
right.
mean, hey, thank you, sir.
Just kidding. All right. Thank you.
Your
Thank
Honor, can I
you.
ask one last question? I had indicated to my client, provided he's in compliance with everything that Your Honor just ordered, he can petition halfway through his sentence for early termination of probation, correct?
Yes, that's provided for by statute, so he can certainly petition. Court makes no guarantee as to whether or not I would grant it, but he can certainly petition halfway through.
Fair enough, Your Honor. Thank you. And should he reach out to the probation department today, or will they contact him?
Yes, he can reach out to me.
Yes, you can reach out to the probation department.
Thank you, Judge.
Could I please get the number to call for that, please?
Sure.
Your Honor, we'll reach out to him.
Okay. We're not giving you the number. They'll reach out to you. No.
Okay.
All right.
Can
All
I,
right.
I'm
Thank you, Judge.
sorry, can I ask one more thing?
I can't stop you. Go ahead.
I work till 9 PM tonight. Is it possible for them to call me in the morning?
Yeah, sure.
Yes, of course.
But I need to,
We have that scheduled.
but I need to make that payment today. How do I do that?
On your screen,
Yes, sir.
you're on a phone, so you're probably gonna have to swipe screens. There's a QR code. That QR code will take you to our payment site. You can pay by card there.
Okay, perfect. I'll
Okay.
do that.
Okay, I'd wait until I give it a couple hours so we can get the information entered. Okay?
So how, I can still find that QR code on the website for the 14A court?
Brenner, my office number is 734-973-4883. Mr. Naugle, call my office and my assistant can help you.
Thank you very much, everybody.
You're welcome. You're welcome.
Any other questions?
No, sir.
No, thank you.
All right, good. Thank you.
Bye.
Court does call the case, People versus Andre Smith.
Your Honor. Your Honor, good afternoon, Joe Simon on behalf of Mr. Smith. State your name.
Good afternoon.
Andre Smith.
All right.
Your Honor, we have no factual corrections to make to the pre-sentence report. The recommendation is consistent with our expectation. My client is very remorseful and has done a really good job of putting himself in a position to, I think, fulfill these requirements timely.
All right. Sir, anything you want to say before I impose sentence?
I take full accountability for my actions, not only because I've broken the law, but because I've fallen short of the standards that I hold myself to. So I thank you guys for the opportunity to do better.
All right. Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $100 probation oversight fees. When can that be paid?
Everything today.
Fantastic. Pay that today out at the counter. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. There is no going to any Walmart store in the state of Michigan. I'll set a review hearing that's to be held November 12th, 2025 at 9 a.m. I'll order 365 days in jail that is suspended.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Jerry Walker.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Sherry Walker, who is approaching.
Hi.
Please state your name for the record, ma'am.
Sherry Walker. All right.
Teresa Clare on behalf of probation. Your Honor, Ms. Walker is before the court for a violation of probation hearing. Ms. Walker is in violation of the terms ordered by the court in that she owes a balance of $1,218 having made payments. She failed to complete a substance abuse assessment and or treatment. She failed to complete a mental health assessment and or food and treatment. She failed to complete 25 hours of community service, failed to report to probation as directed, and has 1, 2, 3, 4 new pending criminal cases, one being a possession of drug paraphernalia, a retail fraud, second degree, another possession of drug paraphernalia, a retail fraud, first degree, second offense, and a retail fraud, second degree, second offense. All of those incidences happened after being placed on probation. Given Ms. Walker's non-compliance with the probation and her failure to follow through, probation is recommending that Ms. Walker serve 365 days in jail with credit for 13 days served to date to serve the balance, that she completed in jail farm program with consideration of early release upon completion, waive remaining terms, accept her financial obligations, and discharge her from probation.
Thank you, Your Honor. I did have the opportunity to meet with Ms. Walker and discuss these violations of probation with her, as well as the jail recommendation. We do acknowledge and admit to the alleged violations, and I would ask to argue against the jail recommendation, however, when appropriate.
All right. You mentioned the violation.
Yes, Your Honor.
All right. Go ahead.
So, Your Honor, I was able to have a very long, meaningful conversation with Ms. Walker. And first off, she does want to apologize to the court that she did not complete the terms as ordered on probation. And she does acknowledge that she currently has some pending cases, and I do not want to comment on those as they are still pending, outside to point out that it is my understanding they are all non-assaultive allegations. My client does reside in Ypsilanti by herself. She receives Section 8 housing. Ms. Walker states to me that prior to her receiving Section 8 housing a year and a half ago, she was a resident of the Delana Center. Since receiving this housing, her life has changed in a lot of positive ways, including that she has potential work at a laundromat actually down the street here. She is a caregiver for her mother who resides in Ypsi. Her mother is 83 years old and is unable to really get around. My client is also engaged at the Hope Clinic on Harriet Street and has even spoken to people there about the possibility of potentially volunteering. My client is very concerned that a year in jail, of course, would leave her likely losing her Section 8 as well as then her current apartment that she's been in for a year and a half. She even stated to me she thinks the TV and the lights are still on at home and she's concerned about paying rent, which Your Honor's aware is on the due is usually due on the first. In her case, it certainly is that she has to pay her portion of the Section 8. My client states to me that she came into custody when her name was ran and she was picked up. And she states to me that she does not believe any new charges are coming from that police contact. Ultimately, I'm asking the court to consider discharging Ms. Walker from probation without improvement. Closing out this case and not imposing the jail time so that she can maintain her housing.
Ma'am, is there anything you want to tell me before I impose sentence?
Yes, sir. How you doing? Remember I lived in Montgomery, resided in Montgomery, and we did the Zoom, and you had gave me some community work to do, and I was in the Salvation Army, but the husband and wife got in trouble by using drugs, so they closed it down. But I did do some community work there, so I was there, and also I also was going to my court during the through Zoom. I was doing all that. So like when I opened up my blinds every morning, it was a dope house there and the church that I was doing community work there, service there for you. I was just struggling, because I love to open up my blinds every morning. And so, I was doing so well until one day a friend of mine brought up drugs and I forgot I even did drugs. I was doing so well. And so I got back up here. I went to the Delana Center. While I'm on drugs, I was determined and got on Section 8. And now I live by myself on La Forge. And I'm the only one with the key. And I do believe I left my lights and TV on. And I don't know no neighbors out there because I was only out there a year and a half. I haven't been out there. And then they're like coming through, because we was on the news about the mold and all that kind of stuff. And so Section 8 have people coming through certain house apartments to check the the mold and the whatever that's what's wrong with our apartments since it's been what you call it, new management, ill property. But I haven't been on if you can release me to I haven't been on Tether over 40 years as I was, in juvenile. I haven't experienced being on Tether as an adult. So if you can please release me, if possible, so I can take care, I don't lose my place in my Section 8. And you can put 2 of them on my arm, my wrist, and my ankle. And I would do anything that you want me to do. If you just give me a chance on Tether, I'll pay the fines. I'll drop clean. Because I have a job down the street, the laundromat. I can give you documents of that when I go to work. And also the owner of the laundromat saw my work ethics. And he gave my friend an application to give to me to fill out for as a fill-in. So I have that going for myself, and the whole clinic, I have that going for me. And I just can't do everything. I just can't be locked up and lose everything, be back at, on the streets. And the only thing I love, I will show you, I'll drop clean. if you give me one more chance, release me to Tether. I can show you. And then if I mess up then, I swear I'll just do whatever you want me to do. But please, can I go home?
How'd you come back into custody?
I was on my friend house, lived across the street from me. She was about to do my hair. And next thing I knew, they just busted the door down. And they ran my name. And that was that. And that's how I ended up here.
Because I originally sentenced you back in January of 2023. Didn't do anything on my sentence. We had you set to come back April 10th of this year on the violation of probation. You didn't show up. And now we have you back.
Can I respond to that? My mail was going to my mother's address. I didn't have a place then, and she didn't tell me that I had court and then like that. And I'm not gonna lie on my mom, but I didn't have a place then. I just recently got my place, and I didn't know because my mail was going to 2302.
You knew you were on probation.
Yes, sir.
You didn't call probation.
No, sir.
And you knew that you hadn't done anything.
Well, I had started down in Montgomery.
You knew you hadn't done anything on probation. Right?
Yes, sir. But
you'll hold the keys to whether or not you get out of jail. But I'm going to order the 365 days in jail, credit 13. Defendant is to serve balance. I will consider release upon her completion of the in-jail Dawn Farm program. I'll waive all other remaining terms, including accepted financial obligations, and discharge her from probation without improvement.
what that mean? I gotta do a year.
Calls case people versus Jacob Treadway. He needs to go.
Oh, sorry. Good afternoon again, Your Honor. Joe Simon on behalf of Mr. Treadway. What's your name, Jacob?
Jacob Treadway.
Thank you.
Your Honor, we're here for sentencing. We have no comments on the recommendation other than to say my client can pay his anticipated fines and costs today. And he's going to fulfill all the requirements the court gives.
Sir, anything you want to say?
I'm sorry for the mistake I made, Your Honor, and I'll learn my lesson. I'm never going to drink and drive again. I promise.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient programming, weekly attendance of AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court place you on 12 months probation. You're to pay $855 fines and court cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. You can pay those today.
Yes, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete outpatient, inpatient, or outpatient treatment, at Dawn Farms, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with proof of probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue the sober link testing for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail, credit 1, balance suspended. Thank you.
Thank
Your Honor.
you.
Court calls the case of the people versus Kevin Smith.
Public Defender Natalie Pate with on behalf of Mr. Smith, who's approaching. Please state your name for the record, sir.
Kevin Smith.
Thank you, Your Honor. I have had the opportunity to review the sentencing recommendation with Mr. Smith, and we are asking the court to adopt it.
Sir, anything you want to tell me before I impose sentence?
No, sir, I just wish that I know the decisions I've made while under the influence of alcohol haven't been some good ones. And I just wish I would have seen that at an earlier age. That's about it.
Sentence of the court, $125 statutory fee. I'll order 93 days in jail, credit 32 served. Defendant is to serve the balance. He is to complete the in-jail Dawn Farm program. The court will consider early release upon his completion.
Thank you, Your Honor.
Court does call the case, People versus Rebecca Miller.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who is present via Zoom. Ma'am, can you please unmute and state your name for the record?
Rebecca Miller.
Thank you, Your Honor. I've had the opportunity to review the report as well as recommendation with Ms. Miller. The only very brief correction we have is to her mailing address. She's requesting that apartment 8 be added to that. Outside of that, we have no corrections to the report and would ask that the court adopt probation's recommendation.
Ms. Miller, anything you want to tell the court before I impose sentence?
No, Your Honor.
Sentence of the court, I'll place you on 12 months probation. You are to pay $480 fines and costs, $360 probation oversight fees. When can you pay that, ma'am?
I need a payment plan, please.
A payment plan as arranged by probation.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete an outpatient treatment at Dawn Farms, including all recommended aftercare with status reports to probation. You are to attend a minimum of 3 AA meetings per week with monthly verification to probation. You are to complete 25 hours of community service as directed by probation. There's no going to any Meijer store in the state of Michigan. I'll order 93 days in jail. Credit 2, the balance is suspended. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Ms. Miller.
Court does call the case, People versus Michael Collison.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collinson. Mr. Collinson, please state your name for the record.
Your Honor, this is Michael Collinson.
So, Your Honor, I guess there's kind of two pieces of why we're here. There is an allegation of Mr. Collinson's tampering with the tether, I suppose, and then his discharge from treatment. And I'd like to address both. I hope that the court got, regarding the tamper, I think that, I've had an opportunity to speak with Mr. Collinson for a long time about both of these issues. Looking at the pictures, to me, it looks like wear and tear. Mr. Collinson was brought in with the tether still on his leg. He was in the jail for, I think, 2 days.
The cuts in the strap are wear and tear?
One of the cuts was, I think, already there. There was like a slit in it. As he wore it a few months ago, he noticed it getting worse. So that has been there for months, and there was no allegation that I did not receive a violation report that it was cut. And I think the second one is kind of similar. It seems to be about the same length as the first cut. And from the rubber in between is kind of looking like it's weakening to me. Again, it was not removed from his leg by him. It was removed by the services group that facilitates the tethers. So he got, the cut is deep, but there's no, if he wanted to, he could have gotten it off. I think, like I said, it's been looking like that for a couple months, and there was no prior allegations that he was tampering with it. He's been wearing.
It was just by happenstance that these two cuts that are almost at equal distance happened, cutting through the one part of it that you're saying just wear and tear.
Yes,
Okay.
yes. I mean,
I had no-
again, if he wanted to get it off, he could have gotten it off. I don't
I had no reason to put the Tether.
if he, um, if he was trying to evade, tracking or anything like that, if he did do those cuts, he could have gotten it off, and he didn't. And he came to jail with it on and had it while he was in custody. He's had it since May, and there's been no other allegations of tampering with the tether or evading tracking or anything like that. Again, Mr. Collinson denies tampering with it at all.
Your Honor, I had no reason to tamper with the tether. I ran from the dentist the moment they told me they were going to discharge me. The biggest concern I have here, Your Honor, isn't going back to jail. It's losing the housing that I gained in my sobriety here. I have a lot of, through the blessing of the court, I've made a lot of successful gains. I've completed 74 days in treatment. I never had a behavioral problem at Dawn Farm. The new treatment facility, there was just turbulence. This all has to do with a dental appointment. That's why I get concerned when we're talking about tampering, because I thought this was all to do with being discharged from Oakdale on the leave of absence. I have the contract. I called Oakdale for pickup at 3:30. I was supposed to return to.
How about I'll start and you can add. So turning to the issue of discharging, I think what Mr. Collinson was starting to say is he went to Oakdale. He was at Dawn Farm from May to July. He moved to Oakdale because he got housing through HUD, which he would move to that housing at the beginning of August. He has plans for DTE to turn on the utilities on August 6th. So he moved to Oakdale, I think because the program was a week less, he could complete Oakdale and then move into his housing. I haven't been able to contact anyone at Oakdale. I've made a couple contacts and they haven't gotten back to me. But the reason why we think Mr. Collinson was discharged was because he went to this dentist appointment. The dentist appointment was longer than what his out time was supposed to be. And when he called, they said he was discharged because he misrepresented the time that he was going to be done. They thought he was going to be done at 3. He ended up calling them, I think, around 4 o'clock. That he was done with his dentist appointment. The other piece is that from Mr. Collinson's understanding, is that they didn't understand or believe his representations about the seriousness of his dentistry issue. Long story short, he has a tooth that needs to be surgically removed. It's rotting out of his mouth. When he was at Dawn Farm, they sent him to the ER. The ER can't really do anything because it needs to go through not a normal dentist, but an oral surgeon. Because of the severity of the emergency, they referred him to the U of M clinic. The clinic skipped the normal 4-month wait and got him in for a consult earlier than normal. So that's why he was there. He has referrals from another clinic that he was going to, saying that they couldn't do the service because he needed an oral surgeon, because they couldn't find an oral surgeon in his network. That is why he was at the dentist. Once he found out that Oakdale was discharging him because of this, he did go to Spera. He tried to get a bed at Spera, and they did not have a bed for him there.
You can look at the GPS coordinates, Your Honor. Spera is a safe place for me. Spera is inside the Dawn Farm community, which I just did all this time programming. I had no problem inside of Dawn Farms. The only reason I went to Oakdale, Your Honor, was to receive this housing. Dawn Farms is a very open treatment center, so I'm able to go out on weekends with my sponsor. My sponsor is the boss and owner of Home Solutions 101. He's given me employment. He's even helped me pay the DTE that's scheduled to turn on August 7th at Danbury. I'm not saying that what I should have done, Your Honor, is I should have called my facility the moment I found out that the appointment was at 2:30 and not 11:30. I didn't do that. And one thing Don Farm taught me was to own my part. And like I keep going back. I don't know why I didn't do that. It would have I don't they say I have a thinking disease, and I don't know why I didn't do that. I should have called them. The only thing I can tell you, Your Honor, is I have 120 plus days clean. I'm before you clean. And that means something to me, and I've gained a lot. I'm not asking for like a let go, but I am asking for like an alternative sentencing that doesn't expand on my homelessness. I messed up the probation you originally given me because I was homeless, and just in this short time to be 5 years homeless and to gain this significant opportunity is really huge for me. My biggest fear in this whole thing in my thinking is I don't want to lose this homelessness. I begged and cried on the phone for them to come pick me up. They didn't even give me a chance to show them the paperwork. They didn't give me a chance to drop for them. The wear and tear did start. I ran really fast from the school of U of M on Fletcher Street to Sparrow. Like, I mean, I'm talking, I ran really fast. I've been on Tether before. I ran like a gazelle, man. I ran there trying to obtain bedding because my thought process was if I could get into rehab before the violation of Tether, that I would be able to argue to you that I did the next right thing. Today I'm at your mercy. I just don't want to lose this housing, Your Honor.
So you're indicating that he's denying that he violated it in any way?
I think, I mean, I know Mr. Conlon is very sure that he did not, or very strong, I guess, in the assertion that he did not tamper with the tether. And I guess the discharge from Oakdale by his representation is a miscommunication about this dentist appointment and how long it was going to be, how long he was going to be there, the necessity around the dentist appointment.
I didn't tamper with the tether. I did not try to take off the tether. If you look at the coordinates, I'm not lying. I went.
Well, he wants a hearing on all of this then. Is that what he's telling me?
I mean, I'm asking Your Honor he's done, since he was on probation, he did 90 days in Wayne County. I know Your Honor declined to give him credit for that time. He's done time in our jail here in Washington County. He's been clean for, like you said, over 120 days. He's done almost 70 days at Don Farm and Oakdale of treatment. He has housing that he set up. He has employment through a sponsor that he has set up. I'm asking this court to relieve him of his obligations to this court and the remaining balance, given all of the good things that he has done in the last couple of months. I'm sorry?
I let him out to go to treatment.
I did 74 days of treatment. I'll finish treatment. I will. I'm not trying not.
Your Honor, I just wanted to make the court aware. I know that Mr. Carlson is no longer on probation in this case. However, I am being advised by the Tether agent, so the court is aware that right after he cut his strap and the agent noticed him not tracking anymore, he called and was told that he was kicked out of treatment for a policy violation. They also indicate that they have photos of the tether of when it was installed, and it was a brand new strap, if the court would like to see those.
Well, okay, thank you. Well, I don't know if we're gonna have a hearing. I guess I'm gonna need to see him. I've been dealing with tethers, I don't know how long. I've never seen two parallel cuts or tears, I guess as you're trying to say they are, that are in the fashion that they're in.
And I've dealt with tethers not as long as Your Honor, but I
Wow, that was an age thing. Go ahead.
I do know, I mean, I think the biggest argument here, Judge, is that it didn't come off of his life. I mean, he was tracked the entire time. He didn't, if he wanted to evade tracking, he could have. I mean, people cut them off all the time. And
That's the argument to make, but go ahead.
it wasn't cut off. And he's represented to me that there was an initial, tear in it, months ago, and
Through the metal.
No, not through the metal. There was a tear in the rubber, Your Honor. I noticed it. We went on a trip to Whitmore Lake from Don Farm. Where I was on a paddle
There
boat.
was a tear in it. Why didn't you go back over to community corrections and say, I need a new strap?
Honestly, the tear helped because it made it looser on my.
Yeah, on the back of your leg at your Achilles heel, right?
Well, no.
That's why it's cut the way it is.
No, Your Honor, it clonks on my, I have a bony ankle and it just clonks. Your Honor, again, I had nothing. Cutting off the tether would have violated me and that would have made me lose my housing. And my whole point and my whole day, if you look at I got discharged from Oakdale, Your Honor, on that day.
What I have heard is two. One is that these parallel cuts on the back of his tether strap, or on this tether strap, occurred by circumstances beyond your control. The other thing that I've heard is that you were discharged from Oakdale also for something involving the dentistry, and that was also beyond your control regarding the appointment. The only way I'm going to be able to resolve it is if you want a hearing on it. You're not admitting to these violations. And then I'll make a determination.
I don't think Mr. Collinson wants to admit to the violation, so I think we'd ask for a
And we'll
hearing.
set a hearing.
Wait, Your Honor. Setting the hearing is gonna, if I'm gonna lose the housing, I'm gonna lose the housing. Like, what would I be admitting to? Tampering with my tether? Is that what I would admit to, Your Honor? Is that what the violation is saying, that I tampered with my tether?
Correct.
You have two. One that you tampered with the tether. And the other one being that you left treatment.
But I didn't leave treatment.
Sir, I have heard everything that you and your attorney have said.
I didn't leave treatment, so.
You want to keep talking, keep talking.
I'm just don't interrupt. Okay, I'm sorry, Simpson. I'm sorry.
I'll set a hearing. I mean, that's the best I can do. You can bring me everything and you're saying that there are reasons for all of this, then I'll hear those. But I will tell you with reference to, I don't know in reference to Oakdale, but certainly in reference to the tether, I have great skepticism in what's being told to the court. So,
If I may just explain to Mr. Collinson one thing, Your Honor.
You're probably. Anyway.
Sorry,
You just said those other things. Oh, no, we flipped over.
Plead guilty. I mean, plead guilty, see what he does. Maybe he'll let me back to treatment.
Are you sure?
Yeah.
And I've explained to Mr. Collinson that he's entitled to a hearing on the violation. I also advised him that we can call witnesses. He can tell his side of the story to the court. And I think he wants to admit to the violations.
Well, if he's telling me all of this stuff that I just sat here for the past 15, 20 minutes listening to,
Have a hearing.
what
Yeah, let's do the hearing. You're right. You're right. You're right. You're right. You're right. You're right, Your Honor. Your Honor, is there any way that I can be on house arrest to this new address during the hearing to sign the lease
house
agreement?
arrest will require a tether. We've had our problems with tethers, haven't we? I'll set a hearing in this matter, August 13th, 2025, 3 p.m. This bond will continue as denied until we get to the bond moment. Thank you.
No bond.
Court calls case, People versus Mark Reed.
Good afternoon, Your Honor. Dan Garrett, I'm back. What's your name?
Maureen.
Your Honor, I'll just start by saying Ms. Reed and I.
Karen, the court stands in recess. Your fault.
Proceeding District Court for County of Washington, State of Michigan is now back in session. The Honorable Jonathan Pitman.
You may be seated. You know why that happened on your case, Mr. Guerin?
Say that again.
You know why that happened on your case?
Yeah.
Huh?
Murphy's Law?
Well, no, we were in back, and so we all voted.
Yeah, let's hear this.
All right, and the reason is because when Miss Perny got up and you didn't move.
That's karma.
That's right, it's karma. I'm just saying.
But it should happen on Simon's watch then too.
What? And nobody really expected Joe to move.
That's right.
Court recalls the case of the People versus Reed.
Dan Garrett on behalf of Ms. Reed.
Kamara Reed.
All right, thank you. All right, go ahead.
As I was saying, Your Honor, at the time, we're asking you to follow the recommendation. Ms. Reed would like to engage with Your Honor about how much better she's doing and anything else Your Honor would be curious about. So.
All right, what do you want to tell me?
I've enrolled in classes for the fall semester.
Yay.
So I start those on the 25th. I'm also seeing a therapist that I think is a better fit for me. He's been really helpful. I also, since she did reach out to me about the recommendation she was going to give. I've looked at a couple of outpatient programs that would work for me, that are like in network with my insurance, and also AA meetings that would work with my class schedule as well.
How are you doing otherwise? I hear all the good things you're doing, but tell me how you're doing otherwise.
I'm doing okay. I'm just one day at a time.
Grieving's hard, isn't it?
Yes.
What's even harder, and I was trying to explain to you the last time, was it becomes even harder when you take all of those emotions, and most of them don't even have a name. They're just there, right? And you just start, you don't know what to do with it, so you just start tucking them inside, right? And here comes another one, and you just tuck it, and you just do that, right? And then ultimately, and part of the reason you do that is so that you don't feel the pain, right? But then ultimately that pain kind of comes through, right? You worried me, young lady, you know that, don't you?
Yeah. I think I worried a lot of people.
Yeah, I'm sure. Is that your mom back there with you?
Yeah.
Hello. You worried her a great deal, I bet. What does she have to say to you about all this, young lady?
A lot. But the main thing that she wanted to say to me was that no matter what, like, she's here for me, and that no matter which way, like, I'm gonna deal with my grief and everything else, I have to do it with her. I can't do it myself, and I can't do it quietly. And it's not gonna be peaceful, but I have to do it, and she'll be there to support me through all of it.
Some of that you already knew, right? But how old are you?
21.
21. You thought you knew it all though, right?
Yeah.
Yeah, but life isn't a sort of solitary journey at times. All right. So you're back in school.
Yes.
Mom's happy about that, I bet.
Yeah.
Yeah. Okay. And you found somebody that's going to fit for you, therapy wise and everything. All right. How long ago did your dad pass?
Passed in 2022.
And so you've been just holding it inside all this time.
Yes.
Yeah. Okay. All of it is okay. Your reaction, everything that you've kind of gone through, it all happens for a reason, but it's all okay. You're blessed to have your mother.
Yes, I am.
Right. It's a good feeling when you don't have to sort of endure these things alone, right?
Yeah.
When you came in here the first time, did you expect that it was going to go that way with me?
No, I was really nervous.
You were really nervous.
Yeah.
What do you think was on my mind when I first saw you?
I think that maybe I was being a stupid kid.
Yeah, but I see a lot of those. There was something that said to me, something's going on with you. Because doing this as long as I've been doing it, some people you may expect to be here, and then others you don't expect to be here, and you almost have this curiosity as to why. Right? How'd your conversation go with Miss Clara?
It was enlightening. It was a lot, but I think I kind of got told about myself, which I kind of got told about myself.
Miss Clara told you about yourself?
About my recommendation?
Yeah.
Yeah, I think it was really enlightening for me and humbling.
It hurt in a way. You had to face some things.
Yeah.
And she explained to you that she was doing that because of what she saw and everything else along those lines, right?
Yes.
Yeah. And it's difficult sometimes to accept those things about yourself. Right. But you don't think that means you're a bad person, does it?
No.
Everybody has challenges. Right?
Yeah.
That's a good part. The bad part is, and I don't know if Mr. Guerin told you or not. What was it, about a week after or so? Weeks after. Called him to the bench. Here's the bad part sometimes about coming here. I called him to the bench to ask how you were doing. He told me you're okay. Okay. Why do you think I did that?
I'm not really sure.
Yeah, me either. No, I'm kidding. Here's the thing. And see, this is the bad part that I'm going to explain to you. and Miss Valera knows this. You now become one of those for me that I'm going to be watching. Not in a bad way. Not whatever, although if I do see a sign that you're kind of slipping off or not headed in the right direction, you know, we have no problem grabbing you up. And if you don't want to voluntarily tell us how you're doing, we'll make you tell us. All right.
Okay.
So maybe out of all of the bad things and all of the stuff and turmoil that you've been going through, one of the good things is, and a blessing, I think, in a certain way, you got a whole lot more people supporting you. Right?
Absolutely.
You don't have a reason to fail. We're not going to let you fail. Okay?
Okay.
We got to walk that journey together. We'll walk it together. You're going to get to that place that you're destined to be. This is just a bump along the road, and you'll make it. Okay? But let yourself grieve. Let yourself go through that whole process. Let yourself just let it go, because no matter what, you're only a human. Real feelings, right? Real emotions. That's who you are. So to let you know, I don't expect anything but the greatest. Because when you first walked in and I first saw you, that's what I saw. Somebody that can be great.
It will be.
There you go. Is your mom always quiet?
Yeah.
Is she?
Yeah.
Mom, did you want to tell me anything? You don't have to. You can come on up. Come on up and be with your daughter. I watched the two of you walk in. What's your name?
My name's LaShannon.
Okay. What did you want to tell me?
I appreciate what you just said to her, that you see something in her, because I think she needs to hear it, because she feels like I'm biased.
Well, that's okay. You are.
Yeah. But I just think like, not having her dad here to tell her that is a little bit, you know what I mean? And I don't really have any other male family member who does that. Not that they wouldn't, but like, you don't know her. And I appreciate you even saying, Mr. Gary told me you followed up with her, and that says something. And I think that she needs, whether it's you and her therapist being a male, I just think she needs a little bit like someone who's a little bit tougher will call her on her stuff, because as she says, I'm a softie, I guess. But just thank you for that, because you don't have to do that. You didn't have to do that. And that means more to me than anything else, really. So I wasn't expecting for you to say that.
Well, to the extent it's necessary, you're welcome. But I mean it all. I mean, there's
okay.
There, and the young lady, one of the things your mother just said is so true. Because I think I told you the last time I lost my dad when I was 16, right? And I always say my dad when I was 16, but there were 4 of us.
Thank you.
when your mom's talking about just, sometimes we get maybe too caught up in gender and things, but there's something to be said about the way a mom says something to you, the way your dad says something to you, right?
Yeah.
But I had two sisters. So when I lost my dad, I had two sisters that lost their father. And each of them had to kind of pull through and do that and find those role models, find those people that believed in them. Okay. I don't always ask why my paths cross with whoever it crosses with. I sometimes just thank the good Lord that it has. And so, again, well, this is a bad thing. I'm just thankful that our paths cross.
Me too.
Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly, the alcohol screening assessment identifies the benefit of intensive outpatient counseling, attendance at weekly AA meetings, and abstinence from all intoxicants. Probation, the court will therefore follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court. I will place you on 18-month probationary term. You are to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, $540 probation oversight fees. When can you get that paid?
I can, if I can do a payment plan, I can do 1,000 today, the rest on a second.
1,000 today. Let me ask you, is that your money? Yeah, because you're 21. Whose money is that?
My mom's.
Your mom's money?
Yeah.
Cool.
I'm getting my associates in human services right now.
What?
I'm getting my associates in human services. I have 4 semesters.
Okay. And are you over at Washington or?
Yes.
So how much more do you have to go?
4 semesters.
Huh?
4 semesters.
To go?
Yes.
Ms. Valera, what were the total fines and costs? Well, let's do it. Somebody help me add. How many classes are you taking?
15.
Thank you. How many classes are you taking?
4.
4? What was your tuition bill?
It is around $3,000.
Pardon?
$3,000.
About 3?
Yes.
All right. You young lady, this is, I guess, the court's investment in your future. How about that? We'll do the 1,000. You make sure to do one thing. You make sure to pay your mom back. I'm going to waive $595 of it. So once the 1,000's paid, you're done. That's because you got that tuition bill. You got to make sure it's paid.
Thank you so much.
There should be no use of alcohol, recreational marijuana, or any illegal substance should be subject to random testing as requested by probation. Case people versus Jonathan Pitman.
Good afternoon, Assistant Public Defender on behalf of Mr. Pitman. Please state your name for the record.
You need to unmute Mr. Pitman, state your name. No, it's not for, he's got very bad Wi-Fi.
I'll let him, Judge, he might be able to pay it off by then.
Okay.
He was here, he wanted to be here to be respectful to the court, but he had his kids with him. And,
I'll adjourn it out to that day.
Okay.
Jonathan Pitman. Yeah. Okay. Yeah, he just dropped though. Well. Oh, he got outside. Okay, unmute, young man.
Hey, can you hear me?
Yes, we can hear you. Can you hear us?
I hear you loud and clear, Mr. Simpson.
All right, because I almost had to issue a bench warrant.
No, that's not needed, sir.
No, I could see you. You were bad. It was bad Wi-Fi. I wouldn't do that to you.
I came today to make my debut to you, but the fire alarms went off.
All right. When can you get this paid? You owe $420.
Tomorrow.
Tomorrow?
Tomorrow I can, or can I do half tomorrow and then half? Because I currently am on my way to start working on Monday. I got a new factory job, so it's actually pay a lot more than where I was at. So, I could do half tomorrow, and I could do the other half by the 5th.
By the 5th?
Yes,
All
sir.
right, here's what I'm going to do. You're to pay the balance by August 8th, 2025.
You got it, Mr. Simpson.
Okay. You take care of yourself, young man.
I had a souvenir for you while I was there too, sir.
Souvenir for me?
For you. You my favorite, Judge. You my favorite.
Well, I appreciate that.
Let me tell you something, Judge. Not off the record. I had two beautiful girls that wanted to say hi to you. They're my daughters. They
Okay,
said,
where are they?
They right here. Come here, girls. Come here. Say hi, girls.
Oh my goodness. Look at that. Hello.
Say
What's
hi,
your
Justin.
names?
What's your name?
Isabel. My name is Nova.
Okay, you guys are beautiful.
Thank you.
You're welcome. So
yes,
it's good they take after their mom because daddy didn't give them those looks. All right.
Yeah. I don't want a bench warrant, so I'm not gonna fire back. I don't want a bench warrant.
Okay. All right. You get this paid off. You take care of yourself and those two beautiful daughters. All right.
Thank you. Hold on, wait, Judge Simpson, wait.
Okay.
Somebody else want to make a debut. You see her?
Oh my goodness.
Yeah, she's saying hi to you.
Oh yes, I see that. What's her name?
Her name is Journey.
Journey. All right.
Yes.
So you got any more kids you gonna pull out of the woodwork? What?
No. No. No, sir. Okay.
Okay. All right.
And I'm not driving.
Okay. Yes, sir. Okay. You take care.
You too, sir. Thank you.
All right.
Bye-bye.
Mr. Motto, if you could please unmute.
Good morning, Your Honor.
Good morning, sir. Sorry for the wait. So we are here in Jace Hicklin 5805304337. If you could please begin with your preliminary motion.
Yes, Your Honor. Making a motion to suppress and dismiss under 3.1B. Discovery request was made on July 13th. The state has failed to respond.
Right, so let me go ahead and confirm that we have received the documentation on our side. I see that we have filed requests for discovery on our end, filed July 17th. The proof of service as well as filed July 17th. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Today's 13 days from the filing of that. It is a 14-day requirement.
Understood, Your Honor, but my request was mailed to the prosecutor's office on the 13th of July.
But mailing isn't receipt of the
Right, yes.
actual, okay.
Correct, Your Honor. So there's a 3-day business rule, mailing rule. I understand when it was filed with the court, but the question is when it was submitted to the state prosecutor's office. And presumably, Your Honor, mailing on the 13th, they should have received that within 1 or 2 business days. Even giving them 2 business days would still be timely, in my opinion.
Okay. 1 second. All right, I just looked up the RLJ. All right, pursuant to the request for discovery, I see that it is filed and the proof of service has been filed with the court as well. I'll go ahead and suppress all documentation not received with your office, and as such, dismiss both counts for lack of foundation.
Thank you very much, Your Honor. That's the only matter I have for today's calendar.
Thank you for your time.
You're welcome, Your Honor. Have a good day.
You as well. Can you not pull anyone in yet? I just need to look up the mailing rule really quickly. You know, do you know about that? Because I have discovery upon written demand of the defendant at least 14 days before a contested hearing filed with the court. If the prosecuting attorney. I've never heard of the 3-day business rule. IRLJ mailing rules. Okay, I'm gonna have to look that up in my own free time afterwards. And that was IRLJ 3.1. Okay, let's do Shapiro. Mr. Anderson, if we could please unmute. Why am I missing a lobby? Did I? Hi, it's been a while.
Yes, it has.
It's nice to see you. Oh, did I file the wrong one? Did I do a lobby instead of Abdramov? I'm sorry, I think I might have filled out a separate form. Do you see a lobby in there? Okay. Okay, thank you. Just really quickly. What? I know.
If it makes it
There's
easier, Your Honor, we could always call that case first, and if
No.
it was the same result, then you don't have to redo anything.
I know, that's why I actually am keeping the piece of paper, because I was like, I might not actually have to change anything, but yes, there's nothing filled out. So let's go. So Aubrey Alave 580411-835, if you could please begin with your preliminary motion.
Thank you, Your Honor. Moving to suppress the 6.6 certification. If I can get to it. When we look at the certification, there's not a signature anywhere. So for that reason, it fails 6.6. We ask for suppression and dismissal.
Okay, so I will go ahead and suppress the SMD device, any readings from them. I am looking through the report to see if there is any visual estimate of the speed. I do not see anything other than I observed the defendant traveling at a visibly high rate of speed. And so as such, I will go ahead and dismiss this for lack of foundation.
Thank you, Your Honor.
Your next matter is Aniket Chandrak, 580415-870. If you could please begin with your preliminary motion.
This one's going to be very easy, Your Honor. I didn't receive discovery in this one.
Okay.
So the 3.1B motion is suppress and dismiss.
All right, well, that feeds in perfectly to a quick question. So I know that I just wanted clarification because I want to make sure that I am ruling on this correctly. It's 14-day rule. It's 14 days inclusive of the weekends, correct? Pursuant to
Yes.
Okay. Are you aware that there's a 3-day mailing requirement as well? Just like if you mail, so for instance, if today, there was someone who, I need to look into that. I just felt that you were so knowledgeable of it. I was going to ask if you could refer me to the right statute.
Honestly, Your Honor, I've never heard of that. It's not under the IRLJ's rules whatsoever. Is my understanding. That being said, it might be under like the rules of evidence or civil procedure or something along those lines. It gets tied in that way.
Yeah, I'm gonna have to look into that because that was sort of, I feel that I've seen it all and know the IRLJs pretty well at this point, and I just felt that that was sort of a novel argument, but I felt like if anyone knows novel arguments. So, okay. So
Well, I
let me go
appreciate
ahead.
your trust and faith in me. Unfortunately, it was misplaced this time.
I think I think it was just I guess I'll discuss it later. Let me just go ahead and look at your filed request. You have
With that question, by the way, normally we see things like 5 days, 10 days. So if it's 14 days, I think they're probably accounting for that mailing time anyways, 'cause it's allowing for the weekends. So even if that was the case, I think that's probably a bad argument in that situation, maybe.
Yes, I think the thought was, the argument was for today, for to request for suppression of documentation today for lack of discovery received after a request for discovery was made. After looking at when the request for discovery was filed, it was filed only 13 days ago. That is inclusive of the weekends. I said that technically they have another day to fulfill the request for discovery. And then the argument was made that the 3 days before it were included. Now that I'm saying it, it sounds like a very ludicrous argument.
And Your Honor, the words are in the ILJs are the words receive as well. So it's not like the mailbox rule or something like that. It's the word of receive, which is kind of key to that.
I think that's what it was. It's the mailbox rule. Oh my goodness, that throws me back to law school. That is the mailbox rule, isn't it? Oh my goodness, I never thought we would have to talk about that again. It is the mailbox rule.
Things like mailbox rule and all that applies to contracts. This isn't a contract, but beyond that, even if it were to apply, the wording gets around it by using the word receive.
In the sense that they must receive it after within 14 days.
Correct.
You're good. You're good. Thank you. That's mailbox rule. Wow. That takes me back to like studying for the bar exam. That's interesting. Okay.
I just remember learning about a firefighter rule and going, what the heck is this?
And then it's funny because somehow it'll come back into play. That's crazy. Okay, yes, you are correct. So I see that it's filed on May 16th. I do see the certificate of service attached as well. So based on that information, as an officer of the court, it is well outside the 14-day window for you to receive documents. Will suppress any documentation not received and as such dismiss for lack of foundation.
Thank you.
It is the mailbox rule. That's crazy. It's totally the mailbox rule.
I remember having that in contracts. I had one of those professors that gives you like a 4-page, fact patterns that spot all issues. And you're like, oh no, there's like 50 issues every time.
Yes.
Yeah.
That's so funny. That he totally mailbox ruled me. So funny. I'm like, what is this rule? I even spent a second trying to find it because I'm like, I don't think I remember a 3-day wait period. And you're totally right. You're totally right. He mailbox ruled me. Tanya Martinson, 580476303. Please begin with your preliminary motion.